session is on Doctrine of Basic Structure. Now, basically, yesterday I discussed about the constitutional amendment procedure. So, a logical follow-up to that would be the Doctrine of Basic Structure. We are going to discuss the Doctrine of Basic Structure in this session. Now, before I begin with the Doctrine of Basic Structure, I'll begin with I'll first tell you what is the meaning of a doctrine, because many a times people are not aware what a doctrine would mean. So let's begin with understanding what is the meaning of the term doctrine. How do we understand the term doctrine? Okay, a doctrine is a technical term, jargon related to Indian polity. Doctrine basically means a set of principles given by the judiciary in order to clarify on the provisions of the constitution. So you can understand this as a clarification or principles. This will be either related to the application of, it will be basically related to the application of provisions of constitution. See, basically it is humanly not possible to write everything on a paper, isn't it? In the constitution also, there are a lot of things which are not very clear, or where you don't have a way forward. You get questions. Now, whenever you have questions on the provisions related to the constitution, whom will you go to? Obviously, you will go to the judiciary. Why judiciary? Because apart from adjudicating, judiciary is also responsible for interpreting the constitution and telling us how to follow it. So, in its interpretation of the constitution, judiciary lays down doctrines to give clarification. Doctrine of basic structure is the most important, but otherwise, you also have doctrine of reasonable classification, doctrine of severability, doctrine of eclipse. We talk about doctrine of essentiality, or doctrine of waiver, doctrine of pith and substance, doctrine of colorable legislation. So there are many doctrines that we come across in the course of our discussion. Remember, every doctrine will be related to one article in your constitution, because it is basically a clarification of a specific provision in the constitution. Now, when I tell you how doctrine of basic structure emerged, you'll understand how doctrines help us in the application of the constitution. Let's understand about the basic structure. Now, for you to understand about the basic structure, you should first follow the fact that when you look at the entire provision procedure of amendment as given in the constitution, there is a basic problem. The problem is that we do not know. The problem is that we do not know uh, uh, whether the parliament has absolute power to amend the constitution. Going by the procedure, you feel that parliament has absolute power to amend the constitution, but there are several questions that come into the picture, like, if so, does it mean that parliament can also change the core values or core pillars of the constitution? Now let me explain it like this. See, basically 368 gives you the procedure to amend the constitution. Now, in the procedure, it clearly says as long as the procedure is followed, Parliament can amend anything in the constitution. Parliament can modify, insert, repeal, add, modify, repeal anything in the constitution as long as the procedure is followed. Now, I have a question. What if the government, because it has absolute majority, it has very good majority, the present day government has very good majorities, it is ruling in more than three-fourths of states in India. If the government tomorrow decides that parliamentary form of government should be replaced with presidential form. Remember, parliamentary form is a core feature of our constitution. With the presidential form, can the government do? It can do as long as the procedure is followed. It can do as long as it has the necessary majority. The government of the day has the majority, follows the procedure, and it does it. Speaking by the rule, it is correct because it has followed the procedure. But now let's look at the moral part of it. Do you think it is correct to replace parliamentary form with presidential form of government in a country like India, where you have huge diversity? The answer is no. The founding fathers of the constitution, the constitution constituent assembly members, identified parliamentary form of government as an indispensable feature of the constitution given India's diversity. They wanted an accountable government. By changing parliamentary form of government to presidential form of government, you are shaking one of the core pillars of the constitution. So the question here is, does the parliament have the power to even change the core values, principles, or pillars of the constitution? This question was raised in the Supreme Court several times. Okay, initially the Supreme Court said no. It cannot. It can. It can change anything in the Constitution because 368 gives absolute power. Then Supreme Court said no, no. There are certain provisions in the Constitution which are very important, which cannot be tampered with, like the fundamental rights. Then the Supreme Court finally said no, no. There will be many provisions in the Constitution, the core values and pillars of the constitution that cannot be tampered with. And that is when the doctrine of basic structure was laid down. So the doctrine of basic structure is necessitated. It was brought into existence because 368 only gives you the procedure. It allows the parliament to amend anything in the constitution as long as the procedure is followed. So 368 does not impose any limit on the amending power of parliament. Now, the problem is when no limit is imposed on the amending power of parliament, automatically this will result in misuse of power or abuse of power. Okay, and there could be a possibility misuse of power in the sense that the core values and foundational pillars of the constitution may get affected. One of the examples that I've given is parliamentary and presidential form of government. Another example could be secularism, could be socialism. These foundational pillars and values can also be tampered with. Now, do you think there is a need to limit the amending power of the parliament? The answer is yes. Therefore, in 1973, in Kesavananda Bharati case, Keshwanand Bharati versus Union of India. Sorry, State of Kerala. I'm very sorry. Keshwanand Bharati versus State of Kerala. In this case, Supreme Court declared, propounded the doctrine of basic structure. Okay. In this case, please remember, for the first time, the doctrine of basic structure was explicitly spelled out. It was laid down. In this case, Supreme Court said it identified the features of basic structure and it said these features cannot be disturbed. Meaning, Parliament, you want to amend the constitution, please feel free. You can do it, but you should not affect the core features of the constitution. What are the core features of the constitution that Supreme Court, has identified? As Supreme Court, as the final interpreter of the constitution, has identified certain features of the constitution which I consider as basic structure of the constitution, and you should not disturb them, you should not tamper with them when you're amending the constitution. If you tamper them, automatically I'll declare it as invalid. A classic example of which is the 100th not 100th 96th constitutional amendment act, which is related to the NJSC, National Judicial Appointment Commission. I'm sorry, it is 96th or 98th. I'm not able to recollect the number exactly. But National Judicial Appointment Commission, NJSC, was declared invalid by the Supreme Court because it was violating one of the features of the basic structure, that was independent judiciary. So please remember, the basic structure doctrine was never defined. Please remember, it was never defined by the Supreme Court. Supreme Court only identified the features of basic structure and it said these features cannot be violated. Point number one. Point number two. Please remember, doctrine of basic structure, the features were not laid down in one case. They evolved over a period of time. In Kesavananda Bharati case, doctrine of basic structure was declared and a few features were identified. The subsequent cases, new features were added. For example, we have an important case called Kihoto Hola Hoon versus Zach. This case is extremely important. It is related to anti-defection. In this case, Supreme Court upheld the anti-defection law, but it also declared free and fair elections as part of the basic structure. Likewise, in S.R. Bommai versus Union of India, in this case, Supreme Court declared federalism or secularism as part of the basic structure of the Constitution. So the basic structure doctrine evolved over a period of time. It was directly declared in Keshwananda Bharati case, but its roots can be traced back to Golaknath versus State of Punjab, because in Golaknath versus State of Punjab, Supreme Court for the first time imposed restrictions on amending the fundamental rights. Okay, I hope I made myself clear. So basically, you have to remember that basic structure was laid down, doctrine of basic structure was laid down to limit the amending power of parliament. No doctrine will be mentioned in the constitution. It is a judicial interpretation. Basic structure never defined. Okay, basic structure features identified. Okay, please remember, basic structure evolved. It was an evolved doctrine, evolved over a period of time, because in several cases post Keshwananda Bharati, Supreme Court had declared other features of basic structure. I will not be surprised if tomorrow Supreme Court will declare a new feature of basic structure. So it can evolve over a period of time. What is the importance of basic structure? See, basic structure is a very important judicial innovation in India, because it is an attempt by the judiciary as the interpreter, by the Supreme Court as the custodian of the Constitution, to preserve the core values and pillars of the Constitution, to ensure that the vision of the founding fathers of the Constitution is kept intact. So the importance is, but it limits the amending power of the parliament. The idea is to preserve the core values of the Constitution. Basic structure has been criticized. Several people have said that it is judicial overactivism. A judiciary cannot enter into this sphere. What is the point in undermining Parliament, which is an elected body, which is a legislative body, its power to amend the constitution? How can it be restricted by judiciary? There have been a number of arguments in support and against basic structure, but by and large, basic structure remains to be, even today is a very important innovation, a very important judicial doctrine that has to a large extent played a very important role in preserving the core values of the constitution. Now, this is about the basic structure. I'm not getting into the features of the basic structure. I just wanted to tell you what is a doctrine, what is the importance of basic structure. So this is it about the basic structure. In tomorrow's video, I know this today's video is a little short, but the topic is a very small topic. Tomorrow's class, I'm going to see you with a topic on social issues. Okay, do join me tomorrow at 9 o'clock. Thank you so much. Bye bye.